All right, in this lecture, I'm going to discuss the process at the Texas Supreme Court, what happens once a petition for review is filed. I've also included some resources that are linked to this lecture, a couple of PDFs that describe each component of a petition for review and gives you a little more guidance about what specifically each element of the petition for review requires. As well as, and you should always be looking at the rule itself for petitions for review. Texas Rule of Appellate Procedure 53.2 details in the court's language what it wants from each section. So that is always a reference to you. One of the staff attorneys, current staff attorneys at the Texas Supreme Court, the staff attorney for Chief Justice Hecht, Martha Newton, is a friend of the class, and many of these slides are taken from a presentation she's given in the past. So I just want to acknowledge her hard work in helping update this lecture on current practices at the court. Okay, so what I'm going to talk about very briefly, I'm going to address jurisdiction, highlight some resources where you can access more details about what is required by the petition for review under the rules and those components. And then the bulk of this is going to be walking you through the internal process at the Texas Supreme Court, how the judges use the petitions for review as part of their decision-making process to decide which cases to grant. And then once they've decided which cases to grant, how things progress from there. So first, jurisdiction. So there is a separate section required in a petition for review that you need to address the basis for the court's jurisdiction. That means you need to be citing Texas Government Code Section 22.001A. That is the statute that establishes the court's jurisdiction. And that statute provides that the Texas Supreme Court has jurisdiction over civil, not criminal matters, of appealable orders or judgments of the trial courts. It has to be a final judgment or an otherwise appealable order. You have an otherwise appealable order, in this case, via the interlocutory. It's an interlocutory appeal of it's a permissive appeal. So that becomes an appealable order, even though it's not final. But you have to establish that your judgment from the trial court fits in the category of an appealable order or a final judgment. 22.001A also talks about the court's jurisdiction being established by an issue that presents a question of law that is important to the jurisprudence of the state. And you're going to hear that phrase several times in this lecture. I know that is the core basis of the Texas Supreme Court's jurisdiction. And this statute has been tweaked fairly recently. There used to be some other components that you had to establish under 22.001A, but really now it's the nature of the order from the trial court, whether it is subject to the court's jurisdiction, that it's a civil and not a criminal matter, and that it presents a question of law that is important to the jurisprudence of the state. I flag for you here that it's talking about a question of law. That's a clue to you right there that the court is less interested in facts here. And it's right there in how their jurisdiction is defined. How else can we tell what would make a case important to the jurisprudence of the state in the court's mind? There's a rule, the Texas Rule of Appellate Procedure 56.1A, that lists what it calls considerations in granting review. And these used to be also mirrored in the old government code provisions. So even though the government codes doesn't establish a jurisdiction specifically by these elements, they kept it in the rule. So it's, again, a pretty clear indication of what the court thinks is important, what's going to get their attention. And I've highlighted some that will be of special interest to you as you put together your petition for review in this case, because you have some of these pretty clearly presented in Sugarcane Seneca's case. So TRAP 56.1A says that important considerations in granting review include, is there a dissent in the Court of Appeals? Why would that be important? Well, that means some of their other judge buddies haven't totally agreed on what the law is in this area. Disagreed enough where one of them wrote separately at the Court of Appeals. Court of Appeals justices are super busy. They do not have time to write on stuff because they think it's cool. They really have a legit disagreement about what the law is. And the Texas Supreme Court, a lot of them used to be on the Court of Appeals. These are still their colleagues. So when they see the Courts of Appeals justices not agreeing on an issue of law, it's a flag to them that like something's going on here, that maybe we need to look at it a little more carefully. And some of the judges will actually flip to the back of the petition for review and read the dissent once they realize there's a dissent, maybe even before they read your petition for review, to see what the dispute is, to see what the dissenting Court of Appeals justice has to say about the issue. Another basis consideration for what might be important to the jurisprudence of the state is there's a conflict among the courts of appeals. So the Houston First Court says the rule's X, and Lubbock or Amarillo says it's Y. The court in general thinks the law should be the same in Texas. And so if you can establish that different courts of appeals are coming out differently on a legal issue, that's going to make it important to the jurisprudence of the state. Statutory construction or the validity of a statute also gets their attention and is listed in TRAP 56.1A. Constitutional issues, although are also considered important to the jurisprudence of the state, although they are probably going to resolve other, they only reach constitutional issues usually if there isn't some other way to resolve it, a more straightforward way to resolve it. So while it's interesting, and particularly at the petition for review stage, when you're trying to get the court's attention to discuss those constitutional issues, but the fact of the matter is when it comes down to writing the opinion, they will resolve other issues before reaching that constitutional issue. But for petition for review purposes, I mean, I just think about like you want to show them that here's something shiny. Look over here. And a constitutional issue is definitely shiny and going to get their attention. Two other items listed in 56.1 that are considerations in granting review is if there's a big mistake, like the Court of Appeals error, again, of law, not a fact. The error of law is of such importance to the state's jurisprudence that it should be corrected. So that could be really an error correction, not necessarily a new rule, but that's still going to get their attention and is an important consideration in granting review. The last item mentioned in 56.1A is that it's an issue of first impression, that the Court of Appeals decided an important issue that should be resolved by the Texas Supreme Court, but hasn't been yet. The more you can identify or align your issue with some of these considerations in 56.1A, the more you are speaking the court's language on what is important. This is, they wrote these rules, so they're telling you that this is what they think is important. And if you can use that terminology in 56.1A in your description of why this is important, you're speaking their language. Okay, the requirements for the petition for review, again, get out the rule. TRAP 56.3.2, there's a little paragraph that describes what they're looking for in each section. You should be reading those as you write and prepare your petition for review to make sure that you are being responsive, that your petition for review is responsive to what they're asking for in each section. Two other good resources that I've attached to this lecture that Doug Alexander, who has a great paper that has been updated over the years, but particularly section 6 of that paper, it's called Anatomy of a Petition, essentially goes through the rule section by section and gives you a little more insight on a practitioner's insight on how to put together each section effectively. And what I like about Doug's approach is that he is developed that paper by talking to the staff and the justices at the court. So he's not just giving, that paper does not just give you advice about what he thinks makes a better petition for review, but it is informed by interviews with people at the court saying, this is what's helpful to us, this is what we're looking for. One of the early iterations of this paper, I was at the court and was part of that team that was like, don't do this instead. And so I can verify that what is in that paper is what at least most of the judges and the staff are looking for, what's going to be helpful to them. The other document that I've attached to this lecture is the Supreme Court of Texas internal operating procedures. It's also available on their website. The clerk of the court, Blake Hawthorne, puts together, like, this is how we say it works at the court. This is our process. It's a great document to supplement this lecture, actually, because it does just walk you through how a petition for review moves through the process. But for looking at what is required and needs to be in your petition for review, I'm going to point you to section 4F of that paper, sections of a petition for review. And it is a little more just straightforward and meat and potatoes on what needs to be in there as compared to Doug's, which has a little more persuasive bent to it. But together, if you take those three elements, the rules, Doug's paper, and the IOPs at the Texas Supreme Court, you should have a really good above average practitioner understanding of what each section needs to be and what the court is looking for. You can also take a sample petition as you're looking at these rules and read the petition along with it to see, oh, okay, this is where this is how they've complied with the rule, or this is how maybe they could have done it differently. You can use these three things as a guide as you look at some examples. And if you have questions about any specific section, just send me an email or come to office hours so we can talk about it. Okay, this is the fun part, the overview of the petition process. So I'm going to talk about each of these a little bit in a little bit more detailed way in the upcoming slides, but I wanted you to have the big picture on one slide, how it works. So a petition for review is filed. There may or may not be a response. There may or may not be a reply brief. But before, once those things are in, the court votes, and they vote this first time individually. It's online now. They used to have like purple pieces of paper that came up with the petitions. But there's an initial vote. Are we interested in this? That's before they have a conversation with each other, they're individually voting up or down. Then after those votes are all in, they do have a conference where they actually sit at a table and discuss. And then they decide, do we want to know more? And that, do I want to know more, comes in the form of requesting a brief on the merits and asking a law clerk to prepare a study memo that summarizes the briefs on the merits. Then they vote again independently, just check, am I interested in this still? Do I still want to talk about this? They have another conference to discuss whether they want to grant the case based on the study memo and the brief on the merits. If they don't get enough votes, it gets denied, and that's it, even after they prepared the brief on the merits, or it gets set for argument, or there is a third option called a per curiam opinion, which I'll talk about a little bit more, but that in a minute. That is the overview, though, of the process. Okay, so you file your petition for review. What happens? It's like nothing for 30 days. Once the petition is filed, the clerk's office, that's the office that used to receive the paper documents, but now processes the electronic filings. They hold the petition for 30 days. And what I have here is a photograph from back in the day when they were actually paper, and they would just sit on this little cabinet for 30 days with nothing, so nothing happens unless there's an emergency motion attached to it, which is relatively rare. So the petition sits there for 30 days, waiting for a couple of possible things to happen. The other side has 30 days to file a response. So they can file sort of the appellee's brief. It's to the petition for review, just called the response. They can also file what's called a response waiver, which is just a letter that says, we're not going to file a response. We're going to save our clients some money and not file a response. Usually those letters also say, hey, and if you decide you're interested, let us know and we'll be happy to file one, court, if you're thinking about being interested in this. Why would you do that? The court, why would you file that letter? Why wouldn't you want to advocate for your client in every possible scenario? Well, the Texas Supreme Court has said that they will not grant a case or ask for briefing on the merits even without requesting a response. So you don't really need to file a response and be afraid that your client's gonna lose out on their side of the story being told. Because if the court's interested at all, and it only takes one judge to do this, to vote to request a response, the clerk will call them up and say, the court wants a response. You have 30 days starting now. So either response gets filed, there's a response waiver, a letter that says we're not filing one unless you want it, or 30 days pass. One of those three things happens while the petition is just sitting there. No one's reading it. The court doesn't have access to it during that time. Once one of those things happens, the clerk, they used to bring it up on a little like hand cart, the stacks of petitions for the week. Now the clerk just releases them electronically to the court so that the court can read the petitions online and vote on whether they're interested in hearing more. So that's what I'm going to call the initial voting process. There's 10 to 15-ish petitions for review filed at the Texas Supreme Court every week. So every week the court has, each judge has 10 to 15 petitions to read. That's why when we've kind of said they'd spend 0 to 5 minutes on each one, or 15 minutes if they're really interested, I guess. It's because they have a big stack of them. Every week there's just another pile. So they get 10 to 15 every week. They have a 4-week deadline to vote. So the ones that they get today, the votes for those are due in a month. Different judges vote on different cycles. Some of them keep up with it and they're voting on the ones that come in that week. Others are sort of behind. Others read a bigger batch, every 2 weeks, but they have 4 weeks to vote on it once it's released. If no one votes of any interest, if no one says, yeah, I want to talk about this, yes, I want a response, if no one does anything, it's automatically denied on the court's orders. The court issues orders every Friday. And if no one pulls it off during that 4-week period to study it or talk about it, it just gets denied automatically. So your goal initially on a petition for review is to get one of them to vote to do something other than just sit there and watch it go off the conveyor belt into the trash can. That's what you're trying to do. You need to get one person to say, I want to know more. So votes to do something, what kind of choices do they have? Include requesting a response, which I mentioned a minute ago. It only takes one vote to get a response requested. So while it's positive, because you've got a response, that means someone's interested. It could literally just be one judge. It could be all 9, or it could just be one. So I remember having to tell clients, don't get too excited just because they requested a response. That means somewhere between 1 and 9 are interested in this case. So calm down. Maybe not all of them are interested. It only takes one judge to vote to discuss at conference. So once a month, the court meets, but they would sit around a table once a month and go through the Texas Supreme Court's entire docket, opinions that have been drafted, extra writings, dissents and concurrences, and then at the end, when they're all tired and have been sitting there all day, they talk about the petitions for review that someone has voted to discuss at conference. You only need one vote to make it to that stage. On the initial vote, if you get 3 votes to request a briefing on the merits and the study memo, that means, man, you got a hot case, because usually they still want to talk about, they'll just vote to discuss, and then at conference vote for study memo or briefing on the merits. So it's pretty rare to get that request, those 3 votes, without a physical conference. For your reference, and these votes come up later after they have conferenced and met on the case, it takes 4 votes to grant. So that means you can have 5 judges that are saying, I think this case is a giant waste of time. But if you have 4 that vote to grant, it's going to get set for oral argument. It's going to happen. Dismiss for want of jurisdiction. It doesn't happen very often. I mean, it basically has to be a criminal matter or a non-final appeal, an order that isn't final or appealable. Because as you've seen, their jurisdiction is super broad. It's whatever they think is important to the jurisprudence of the state. So dismiss WOJ is not that common. It takes 5 votes. And in practical matter, really, it takes all of them, but a minimum of 5. To hold a petition for review means, oh, I think this is kind of related to this case that we're working on right now, but I'm not sure. Let's hold this petition until we decide the case we already have kind of in progress, and then we can look at this petition again and see if it overlaps. Does it need to be granted on its own? Can we just do a per curiam opinion after we write the opinion in this other case? It means like we think it's related to a pending case, and we're going to resolve the pending case before we deal with this one. That's a hold. It takes 6 because the court doesn't want to have a stack of cases that they're just holding just in case. A per curiam opinion, which I'll talk a little more detail here in a minute, is basically an unsigned opinion. So it's not, when it's issued, it won't have a specific justice listed as the author. It's an opinion of the court, and it takes a minimum of 6 votes to do that. Okay, conference. They redid it during my last year there. It was pretty shabby before then. Anyway, pretty room. There's that big table where all 9 judges sit in order of seniority. The Chief Justice sits there on the end, and then the next 2 most seniors sit on his left and right and goes down to the end. You can't really see, but the very end of the table is a little crowded, where the 2 most junior justices are basically sharing half the space that all the rest of the judges have. Everything at the court is seniority based, parking spots, mailboxes, all of it. Anyway, I thought it'd be fun to see the picture, and you can see the Texas Capitol there in the background, outside the window. So back to conference 1. So the petition's been circulated. Everyone has voted who's going to vote. And let's say somebody voted to discuss. So it makes it to the conference agenda. And conference number 1, they have to decide, are we interested enough in this case to order a study memo, which means requesting briefing on the merits from the parties. Those are the full briefs, long, like Court of Appeals length briefs. And then those are summarized and analyzed by usually a law clerk, but someone on the court staff. So think about like your petition in terms of you want to give that one judge who voted to discuss. Let's say you have one judge that voted to discuss. You want your petition to provide that judge with something to say at conference. You want that judge to have a good argument. You want to provide that judge with a good argument to convince at least 2 other judges that this case, this issue is worth learning more about. That's how I like to think about a good petition for review, is it is going to be your voice at that table through the vocal cords of one of the judges sitting at the table, trying to get 2 other votes to say, let's get briefing on the merits. You need 3 votes from the court to get briefing on the merits in the study memo. So if you've made it to conference 1, that means you've got at least 1 judge kind of on the hook who's interested, and you're trying to help that judge get 2 more votes. if you're writing the response, of course, you're trying to convince the rest of the court that there's nothing to see here. This is not important to the jurisprudence. This is a non-event. It's a one-off. Even if it's wrong, it's not a big deal. And then the reply is the petitioner again saying, no, it really is a big deal. Anyway, and if you don't, at that conference number one, if for that petition, if you don't get 3 votes to order briefing on the merits, the petition gets denied that Friday. So they'll conference early in the week, and that Friday when orders come out, that petition will get flushed. Another thing to think about, and this is really more about the briefing on the merits, but the study memo, just to give you an idea of what that looks like, what that is, it's like I said, the law clerks usually prepare it, sometimes interns, sometimes staff attorneys, usually law clerks. And it has a very strict 10-page limit, single-space 10-page limit. And in that memo, the law clerk will, and it has a very specific format. I mean, they have to put certain things in there. The law clerk has to check that the issues have been preserved. So that means that they have to be presented in the petition for review, but also preserved in the Court of Appeals briefing and at the trial court. And they have a separate section where they have to verify with record sites that all of that has happened. And then they will identify the major legal issues and the primary arguments of the parties, and then analyze with their own independent research what they think about the validity of those arguments, and then ultimately make a recommendation to the court about whether the court should deny the petition or grant the petition or do something else with it. So let's pretend in this example that you got the 3 judges to vote for briefing on the merits. And so the parties prepared the briefing on the merits, and the law clerk created the study memo, and that got circulated to the court. And now the court is getting ready for the second conference on this petition. And they're probably not going to read the briefing on the merits. They're probably, for this conference, going to rely on the law clerk's 10-page study memo. A lot of the judges don't get that deep into the briefing on the merits until they're preparing for oral argument and then drafting opinions, that kind of thing. So, I mean, not all of them, but a lot of them rely on the study memo for the second conference on a petition. And this conference then is, what are we going to do with this? We have the briefing on the merits now. Are we going to grant this? Is this important enough to be one of the few cases that we're going to have oral argument on? Are we going to deny it, do nothing, let it go? Anyway, these are the choices. To grant, which means we're going to have an oral argument where the court's going to issue a signed opinion. There might be dissents and concurrences. Takes 4 votes minimum. Once a case at the court is granted, it becomes what they call a cause. So that's how the terminology that they kind of distinguish between petitions. They don't just call everything case. Those are petitions until they are granted, and then they become causes. The court could also decide to at the study memo stage, to say, this isn't so important to the jurisprudence that we need to have oral argument, but this was a pretty big mistake at the Court of Appeals, and we think we need to fix that. And so they might decide to issue a per curiam opinion. And the process for a per curiam opinion is quite a bit different in that with the grants, those are randomly assigned to the judges before oral argument. A per curiam opinion goes back to the chambers where the law clerk who drafted that study memo, it goes back to them. And so that judge and his legal team will be responsible for drafting that per curiam opinion based on the study memo. Those are usually, and so it's an unsigned opinion, those are usually maybe new applications of established rule, or there was just an error that needed to be corrected and the court felt like it couldn't let it go, or it's related to another opinion that they just issued and it's sort of a variation on that theme. Very rarely is a court going to announce new law in a per curiam opinion. They save that for the causes. If no one votes to grant or PC the case, then it's denied. You have to have an affirmative vote to do something. Otherwise, the answer is always deny. And then I mentioned they can also vote to hold. Some people call the per curiam and the hold docket the shadow docket. That's because you don't know what's happening. As an advocate and as a client, you just know that the court isn't doing anything on your case. They don't call and tell you, we're thinking about writing a per curiam or we're holding your case for something else. It just doesn't get granted or denied. It just kind of sits on the court's docket. So it's a little mysterious if you're on the outside because there's no action happening, but it's also not getting denied. For people who have worked at the court and now you'll be able to say, well, they might be thinking about a per curiam, or is there a related case that they could be holding this for? And so it's not as shadowy, mysterious as some practitioners make it seem, but that you may hear that term sometime, and that's what it means. That's what they're referring to. Okay, and this is, again, you kind of run through this already, but I wanted you to have a slide that really establishes in one piece of paper what the process is. So once your case that has 4 votes to grant, it becomes a cause. And then the cause process, they schedule oral argument. They prepare for oral argument. That's when the judges and their staffs really dig into the briefing on the merits as well as the study memos. The judges may ask their staff to prepare briefing bench memos to help them think about questions they might have. But before oral argument, the cases have already been assigned. And they do a random draw. It's not by like, hey, I'm interested in writing on oil and gas. Can I have that one? They literally put all the cases, the causes on like a note card and put them face down, and they each draw one. So sometimes people end up with cases that they're not that interested in, and that's just how it goes. So they have oral argument. You've seen what that looks like. And then the court, some judges, not all of them, will circulate a short informal memo to the court called a post-submission memo. Oral argument is also known as submission, part of the submission process. And so they might circulate a short memo outlining their tentative thoughts or which way they're leaning. And then the court will have their monthly conference where the judges have read those memos, if any, and they'll go around the table. The judge who's assigned the case will kind of outline what they're thinking about doing, and then they go around the table. Everyone kind of gives them a tentative vote saying, yeah, I can see that, or I might not be able to go with you on that, and here's my concern. So they kind of do a casual vote and conversation about that. Then it goes back to the chambers, and that judge and his staff draft an opinion and circulate it to the court. That'll be on the agenda for the next conference, that draft opinion. Same kind of process. The judge who wrote the opinion gives a little introduction to, I know I said I was going to do this, but it turned out a little differently once we wrote it. Gives a little introduction, and then we go around the table again, and each judge orally says, yeah, I'm fine with this. I'm for it. Or here's some areas where I have some concern. Do you think you could rewrite this part? Or sometimes just like, no, I'm not with this. I'm going to have to dissent. So that gives, feedback to the author, and the author will go back to the drawing board with that commentary, with that feedback, and revise the opinion, recirculate it and then it'll return to the court's conference agenda, and the same thing will happen. The opinion will get discussed again. Sometimes that'll happen. That can happen 4 or 5 times where they continue to rewrite the opinion to try to keep the 9 judges on or to satisfy concerns. In that process too, at that conference, if a judge says, no, I'm going to dissent, then they have a deadline to circulate their separate writing, whether it's a dissent or a concurrence. Very rarely a competing majority, where one of them will be like, I think I can do this better, and the court split and tries to, that's rare, but it happens. and then they revote until everyone kind of settles down on like, okay, this is the majority that we're happy with, this is the dissent and concurrence, everyone is voted and settled, and then the court issues the opinion, and it goes out with the Friday orders once the court votes it out. There's a kind of a finalizing process that the staff goes through to shine it up and double site check everything, but then it gets issued. Sometimes there'll be a motion for rehearing where the parties will say, oh, you really messed up. Here's an issue that you need to revisit. That motion for rehearing goes to the chambers who wrote the opinion for processing. Everyone will get a copy of it or access to it, but it's the majority's responsibility to respond to the motion for rehearing to the court. So they'll write a memo to the court saying, we read the rehearing and it's, there's nothing to see here, or, good point. Maybe we need to look at this again. We're going to look at it a little closer. Sometimes there might be a small correction and the rehearing might point that out. That gets conferenced again, so that once that memo from the majority chambers gets circulated, the rehearing will be discussed at conference and denied in almost all cases, even if they do change the opinion, and that'll be the end of that cause. The per curiam process is similar on the back end, but different on the front end in that it is not randomly assigned. It goes back to the chambers that prepared the study memo. They create a draft opinion, it gets circulated, they get feedback from the court, they might rewrite it a few times, and then if there are 6 votes to issue it, it gets issued. The difference with per curiam opinions is that there's not going to be a dissent or a concurrence. So you need 6 to vote for a per curiam, but really you need all 9, because if someone says, I'm not for it, and I'm so not for it that I disagree with it, and I'm going to write separately, then the court votes on what to do with it. And sometimes that means converting a per curiam into a cause. Sometimes that means scheduling oral argument and it becomes a full-blown case. Sometimes judges who disagree with a PC will just not vote for it, but the court will go ahead and issue it if they don't vehemently disagree. It depends. Usually you just need the court to all agree, but need a minimum of 6 votes to say, yes, let's issue it. And then the same process on the rehearing. If there's a motion for a rehearing, it goes back to the authoring chambers to make a recommendation to the court on what to do. And this slide is just for your information. This is like the timing on how long things take. I had a few questions during office hours a couple of weeks ago about like, why does everything take so long? And here's just a rough timeline of why your case can sit there for a year before anything really happens. And this is if none of the parties ask for an extension of time to file a brief, which that almost never happens. You can almost certainly add, for every time there's a brief due, there's going to be one extension filed asking for another 30 days. So a lot of these you can almost double. But we talked about the 30 days where the petition is held, and then the judges have 30 days to vote, and then you have to see when the next conference is, and that could be a month away. Anyway, when you start counting those up, you're like, okay, that's 7 months with no extensions from when the petition's filed to the court granting it. So, and that's not even counting the time for the opinions to be written, conferenced. If it's a difficult opinion, it'll be conferenced, 4 or 5 times. So it's a process. Anyway, that is the way the court processes petitions for review. If you've got questions, pop in and ask, or send me an email. I love talking about this. I think it's interesting, and the petition for review really is just such a unique piece of legal writing. But I hope this helps highlight to you where the petition for review fits into the grand scheme of what the court's doing and really what the purpose of the petition for review is. And that is to highlight why the court should spend its limited time and its limited grants in a particular year on your case. That's the message you're trying to get through to the court in your petitions, and I can't wait to read yours.